Hi, it's Shan Wu with an undercolor of law analysis of what's going on with the FBI. Now, the acting Attorney General, Emil Bove, has put out a memo that we're going to discuss, and then we're going to talk about what's being done to fight back against his memo. So, do we all remember who Emil Bove is? He is a former Trump defense attorney. Once upon a time, he was a prosecutor in the Southern District, actually got rather severely reprimanded by a judge over an ethics violation, but that's a different topic we can cover sometime. And he was a Trump defense attorney for all three of the big Trump criminal cases: for the January 6th investigation, for the Mar-a-Lago mishandling of classified national security information case. Those are the two that are now gone, thanks to the Supreme Court, the Justice Department, and also the Justice Department's slow start. And lastly, the one conviction that was secured by the Manhattan DA's office against Trump for the business fraud case arising from him lying about paying the money to adult actress Stormy Daniels, that case. Bove was a defense counsel for all three of those. And as his reward, Trump has planned to make him a very important official at DOJ. He will be the principal associate deputy attorney general. So he'll be like the top aide to the deputy attorney general. But right now, he is the acting, not the acting attorney general, sorry. Right now he's the acting deputy attorney general. The acting attorney general is someone else, McHenry. And because the deputy attorney general is kind of the operational CEO for the department, memos of the kind we're going to discuss tend to be put out by the office of the DAG, the deputy, rather than directly from the AG. So this is what Emil Bove has put out in a memo. We'll put it up for you, and I'll read along here on my hard copy. So the subject is termination, and it says that the memo's referencing a series of directives to fire certain FBI agents. Now, what's important about this, first of all, how odd it is for a deputy attorney general to be involved in this type of a personnel decision. But what's really striking about it is how blatant the political improper reasons are. So Bove writes, as President Trump declared on his first day back in office, quote, "The American people have witnessed the previous administration engage in a systemic campaign against its perceived political opponents, weaponizing the legal force of numerous law enforcement, blah, blah," and the intelligence community, too. So notice there's some nuances in this memo that you may not see covered. That's one of them, is it sweeps up not just the use of DOJ and FBI, but it also now references the intelligence community. So keep that in mind. He then says, for example, the FBI, including the Bureau's prior leadership, take a hint, leadership, you're not long, actively participated in what President Trump appropriately described as a grave national injustice, meaning they dared to prosecute the people who rioted and tried to interfere with the election on January 6th. He also references the weaponization of the FBI's security clearance process. He finds that troubling as well. Again, notice that tie-in to the intelligence community, because if they're in charge of giving security clearances, doing the background checks, etc., he's basically trying to undermine that point, right? What is he setting the stage for? Well, we'll talk about that in a sec. And he therefore says, "I deem these terminations necessary pursuant to an executive order about ending the weaponization of the federal government in order to continue the process of restoring a culture of integrity, credibility, accountability, and responsiveness to the leadership of the president." He then, at the end, concludes that there's going to be further review here because there may be more terminations. And we know from reporting that they want to fire as many as 6,000 of the agents. So the reference to the intelligence community and the security clearance issue there, right, what can that be laying the groundwork for? Well, a lot of the people that are being given access to tons of information are these lackeys of Elon Musk. And you may recall that at one agency, the security people were terminated because they weren't going to let Musk's people into a highly sensitive facility. It's a SCIF. It's to store the most sensitive classified information, because apparently there's no proof the people coming in had any security clearance. So this is immediately questioning this whole need to defer to the Justice Department's background checks for security clearances, and it's questioning whether or not the intelligence community is also being weaponized. The canning of 6,000 FBI agents is obviously an enormous blow to the agency's capability of defending people, watching for terrorist attacks, responding to all kinds of crimes. The tie into the intelligence community is even more disturbing, frankly, because it's directly taking aim at the idea that you can't trust them either. We want to take that over too. And that opens us up as a country to enormous vulnerability in terms of the capability of intelligence, and rather importantly, the perceived vulnerability. I mean, another country, obviously, or terrorist groups looking at the US says, hey, you know, the Trump administration doesn't even like its own intelligence system, wants to get rid of them, wants to do away with clearances. So it opens up an enormous area of vulnerability. Now, what's being done about this? Well, there is some pushback, as we've discussed previously. The pushback's really coming in the way of lawsuits. And the employees, many of the federal employees here, are really doing the work to push back against this. So we see some of the coverage. There have been 2 lawsuits filed already. One is a class action suit on behalf of the 6,000 agents who could be terminated. And the other one is a little bit more narrowly tailored. And I'm going to focus a little bit on the second one. That, I think, is a very good example, again, of the kinds of issues that are going to come up over and over again in these Trump executive orders. So that particular suit's not a class action. They keep it as a John Doe because they want to protect the identities. And a big part of the fight here is the idea that DOJ is telling the FBI, give us the names of the agents, and then once they get the names, it can quite easily go public. And the agents are quite worried about that action of it going public, even aside from the fact of maybe getting fired. So this other lawsuit has a few counts to it. 2 counts under the Privacy Act, suggesting that the agent's private information is going to be distributed. That's violation of the privacy law. 1 count involves a violation of the Administrative Procedures Act, which basically says you can't do things in an arbitrary and capricious manner. It's like there's a process for this. You can't just throw it out the window. Another count, very interesting, is mandamus. Now, you're probably familiar with the idea of mandamus when a judge like Eileen Cannon is so out of line that you're asking the appellate court just to put them back in line, direct them, this is wrong. So this is an instance of it being requested to direct the public official not to do this via a mandamus order. The next count is one we're going to see all the time. It's a First Amendment violation because it's impugning certain political viewpoints, right, to the agents to be fired, and you can't fire people on the basis of their political viewpoints. That's a First Amendment violation. Then there are 2 counts of due process violations under the Fifth Amendment for reputational harm, as well as, again, for privacy. So that's what that second lawsuit's about, and those themes, the First Amendment, the reputational harm, the arbitrary and capricious nature of it, we're just going to see over and over again as these lawsuits start to come forward. And very importantly, this second lawsuit also seeks a TRO, a temporary restraining order, to freeze everything, to stop this from happening at the moment. One question we must ask ourselves is, if that TRO is granted, how does it get enforced? Now, there's a worst case scenario here where you can say, okay, who's going to enforce it? DOJ won't enforce it. U.S. Marshal Service, part of the DOJ, won't enforce it. And you could really come into a problem where Trump's people just keep firing anyone who tries to enforce it. And that's another form of a constitutional crisis. For contempt of that order, the judge has a little bit of power without having to ask DOJ to do anything. So let's say the official is in the courtroom, has not complied with the order, he can be held in contempt, he or she can be held in contempt, and they can be stepped back. They can be put in jail ordered by the judge. But someone has to physically put them in jail, right? And the U.S. Marshals run the federal courtrooms, they provide security, and they were the ones who would be telling someone, hey, going back to the holding cell. And there could be a big crisis there if they're being directed by DOJ, don't do this, because they do provide the security for the judiciary itself. So that's kind of a real worst case scenario of what might happen. But I think we should take heart that these lawsuits are coming up so quick, so fast, and so well done. These are very strong legal arguments, and it should, at the very least, slow things down. And that's what you really want to do in this scenario, is fight them at every step, slow them down. And as the group Indivisible has suggested, in the Senate and Congress, there are a lot of procedural things that can be done, and everyone should, if you feel this way, if you're so inclined, get in touch with your representatives, tell them to stop this process, make it undergo scrutiny. The nominations, they can all be at least temporarily blocked, can be slowed down on that front. And I think the Indivisible people had a very true yet ironic saying, which was, think about Mitch McConnell, how incredibly obstructionist he was for the Democratic agenda, stopping nominations. Frankly, we have McConnell to thank for Merrick Garland having become Attorney General, right? Because he blocked him from becoming a Supreme Court justice. Well, the saying there, and one to remember, I think, is to ask themselves what the Democrat members of Congress should do, and I posted about this. What would Mitch do? That's what they should be asking themselves at every turn here. What would Mitch do? And they ought to duplicate that obstructionist tactic, slow things down, make the other side do it in open, do it in sunlight, and have to do it step by step, very slowly. That's step one in this process. First, you bring it out, let everyone know about it, and second, you do what you can legally to make them go through the hoops and slow it all down. We'll keep an eye on this lawsuit as well as the others, and that's it for now. Look forward to talking to you. Lots to keep abreast of. Keep those replies and comments coming. Happy to hear about what you're thinking about all this. Thanks, and we'll talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.